Good morning and welcome to the David and David on Real Estate podcast. Today we have Jake Newton back with us, and we're discussing one of my favorite topics, which is litigation, the topic that we all try to avoid. But, I think as professionals out there, especially with the volatility we're seeing in the market, I think it's a topic that we all really need to understand to help our clients navigate some of the nuances that we're seeing in the marketplace. So, Jake, so excited to have you back on the podcast. Welcome back.
Thank you. Great to be back.
So, Jake, in our practice, we're trying to close transactions, and we make every effort we possibly can to find a way to get it closed. And if we have to negotiate an extension, we try and do it. We try and buy time. We try and do whatever we can. But eventually, sometimes we just we hit the wall and we've exhausted everything, and it's okay. It's time for you to retain Jake Newton because this is going to litigation. He's got to protect your interests. So maybe just explain what happens at your end, how you guys work as litigation lawyers when you're getting let's just say it's a defaulting buyer on one of these transactions, just can't close, can't get their financing together. They've got deposits in there. So what's your communication? And as part of that, please explain how you get paid and your retainer process. Because I'm always telling them, litigation is expensive and it's costly and way more costly from a lawyer's point of view than closing a transaction. So maybe just take it from there, Jake, and go through your process.
Yeah, certainly. So in a defaulting purchaser kind of situation, the first thing I ask the potential client or even the real estate lawyer who I'm discussing their client with is, is the deal live? What's the status of the deal? Because a lot of times I'm getting calls where the purchaser is going to default, but they haven't necessarily defaulted yet, or breached maybe is a better word. And if the deal, and that happens on both ends. Sometimes I'm getting calls from vendors or lawyers who act for vendors, where the purchaser is going to breach, but the deal's still live. And so the way I practice from the litigation standpoint is that I don't really touch live deals. I think it's the real estate lawyer's job to act for the client until the deal is no longer live. And so that means if the purchaser terminates or wishes to terminate the APS as a result, or the vendor wishes to terminate the APS as a result of a breach, and it's terminated upon that termination, then things kind of flow into my world. And at that point, we take what steps we can, depending on the situation. If that's a vendor where the purchaser has breached, then we're writing a demand letter to the purchaser, or just, jumping right into litigation to claim forfeiture of the deposit and, claim damages once they crystallize, once there's a resale of the property, once we know the carrying costs. And on the purchaser standpoint, if my client's going to be sued, I'm happy to jump on a call with them and, explain what we've, discussed on this podcast and on the last one, about how the situation works, that they can't simply just walk away from their deposit, that they're likely going to be sued, and that they can, retain me at that time. But in that situation, we're almost waiting to see whether or not they will be sued, or not whether or not, but when they will be sued. And that's probably the point of time at which they want to retain me. There's some situations where, I do a review of the agreement and I hear the facts, and, each case is different about why the purchaser, if there's a breaching purchaser, why they might have defaulted. If it's the typical, I just couldn't get financing, I can't afford it, there's not much we can do except wait and make the best argument we can when the litigation commences. But there's some situations where, maybe the vendor wasn't acting in good faith, and it's not always an excuse. Maybe it's only infrequently an excuse, but sometimes we can drum up arguments to kind of put some pressure on the vendor to try to obtain extensions, etc. And so that's generally the process from my end. And then I think David was asking a little bit about like how I get paid as well. So once, I'm happy to have those calls and kind of walk people through it to explain what's going to happen. But once litigation is kind of a sure thing, or that they're sued or they want to sue, then we do up a retainer agreement. We have them review it with me, ask any questions. Once they're ready, they sign my standard retainer agreement, and then we ask for a monetary retainer in advance. And basically, as I spend time working on their file, I have software that keeps records of my time, and what I'm doing with that time, and periodically the software will prepare a bill that multiplies the time by my hourly rate and issues the bill to the clients.
And Jake, the statute of limitations on being sued, is that still 2 years?
It's 2 years, but that's the simple answer. The less simple answer is, and it's pretty obvious in these types of real estate issues, but it's 2 years from the date that you discover or ought to have discovered the loss. And so you discover your loss on the date of the termination, usually, not in every circumstance. But there's other cases where, time might go by, and maybe not necessarily in the real estate world, but time might go by before you discover, or before you ought to discover, that you've actually suffered a loss. And so sometimes there's litigation, or often there's litigation issues around limitation periods, about when they commenced or when they ought to have commenced, based on when that discoverability time was.
So not necessarily the closing date, because if you're still negotiating extensions and both parties are still acting in good faith, then I presume that an argument can be made that the loss hasn't occurred yet.
Well, that's correct. I once the completion date or closing date has gone by, if there's no extension, then the innocent party, or the non-breaching party, needs to make an election whether or not they want to accept the breach by the breaching party and terminate, or whether they want to affirm the contract and kind of keep the contract alive and going. And so if the contract's alive, there's no loss. If it's been terminated, then there likely is a loss. And that's the date that it would start.
I'm smiling because we're foreshadowing into our next episode a little bit, I think.
Yeah, we're going to talk about that case you did with anticipatory breach case, but we're going to do that on our next episode. So this episode, I think we want to get into a case that you recently did. And, so far we've been talking about buyer defaults and things like that, but a lot of our viewership, as you may know, Jake, is real estate agents. And you recently were involved in a small claims court case where the issue was a buyer representation agreement. And I think the viewers would be really interested to hear about what happened in that case, because they're all dealing with buyer representation agreements. And I think this is a great example of how to do things or how to not do things, and lessons that should be learned. So maybe you can just get into that one a little bit.
Yeah, definitely. So this was, I think it was a 2020 case that it started. So it was quite an old one. But earlier in my practice, I did a lot of, I call it the VRA litigation. And so a lot of real estate agents know, when you sign, when you start working with a client, a buyer client, you sign a buyer's representation agreement, where your fees basically are built into that agreement, how you're going to be compensated on a commission basis upon a sale. And I guess it happens more frequently with less sophisticated purchasers, and in instances where there's not really an ongoing, or wasn't, previously an ongoing relationship between the agent and the clients. Sometimes people, find clients online, or they don't have a previous relationship with them. And so I think that kind of comes into play a bit more, where the client may not understand what's in the BRA, or may not understand that they've signed the BRA, and when they don't get along with their agent and they go ultimately with another agent to purchase a property, and they do purchase that property and it's within the BRA's time constraints, their litigation arises where the agent and the brokerage both sue their former client and argue that, we're entitled to this commission under the VRA because you purchased a property within the geographical region and everything that's, within the parameters of the VRA and within the timeline that we set out in the VRA, and that you owe us, the money for that. And people don't, I'm seeing purchasers who don't really understand the VRA, don't really understand that once, that there's a holdover period, even after the VRA finishes, where if they buy a property with a different agent, they may still owe the commission. And because they're buyers, they would actually owe it out of pocket as opposed to having the vendor pay the commission, which is more typical. So it's a difficult argument to make to defend. My clients were purchasers who were sued by their former brokerage, former agent, and the defense, it's Latin, it's non est factum. And the argument basically is that they didn't understand the VRA. And so you kind of have to look at all the facts. And it's a difficult argument to make, but you need to look at all of the facts and consider what was explained to them and what they understood at the time. And so in this situation, the broker or rather the agent appended the VRA as part of an offer. And I'm seeing that happen quite a bit. And I'll get into best practices after I explain, but I'm seeing that happen quite often where the buyer representation agreement is appended to the first offer that's made on behalf of the purchasers. And it's sent all via one DocuSign agreement, and it's in a time constrained manner where, there's maybe an offer date and maybe, there's a quick deadline and big decisions need to be made. And so what happened in this case was that's what happened. And the VRA was executed about 15 minutes before the offer date deadline. And the agent didn't really explain or didn't go through the VRA. That was our allegation. And so during cross-examination, I asked the agent, to explain, to walk the court through what he says he did to explain the VRA to the clients prior to their execution of it, because his allegation was that, yes, of course, I walked them through it, they understood it, they know exactly what the VRA said and what it meant. And so I started my timer, live in court, and I asked him to go through the whole thing, and it took him about 8 minutes or 9 minutes where he was rushing through his explanation. He skipped over important portions. And then I actually had his call logs between him and my clients right at that time. And we said that the only call kind of between them at the material time was about a 4-minute call. And so I said to the judge, I said, that's a big issue, credibility in court. And I said, do you believe the agent that he made or explained the VRA perfectly when he just explained it to you in 8 or 9 minutes where he was rushing through it, but that he could somehow do that in a 4-minute call to my clients? And so the judge agreed and, held that the VRA was not binding. And so my client didn't have to pay the commission.
Wow. What a great case, Jake. I'm glad you brought this up. Like lots of, really great learning lessons there, I think, for the industry. And what I tend to encourage my agents do is, we've put together a buyer presentation for them, which includes like a PowerPoint presentation and then plain English simplified forms, which includes the buyer representation agreement. And what we always encourage our agents to do is at the onset of the relationship, go through that presentation and go through the BRA and leave those forms with the buyer so that in their own time, they can go through them, ask any questions. And then when it comes time to submitting an offer, as you're working with the clients, you're not rushing to the whole process of getting them to sign that agreement without actually explaining it. Right. And I think, with what we're seeing happening in the States where, there was the Sutherland lawsuit and the whole pressure is to, really remove the co-op commission from the MLS listing agreement. I think there's going to be more and more onus on realtors to really explain the BRA and really get their clients to understand that that fee is due and payable, not coming out of the seller's portion of the commission, but that, they have to pay for those services rendered and how that payment is to be made. So really interesting. And, what a great way to present that argument in court, having the realtor explain and then show the call logs that, it's really impossible for him to have done a really good job explaining that agreement in the allotted time frame. Good on you for, really framing that argument really well. But it goes to show, in our industry and for our professionals, how much care and attention you need to, devote to some of these issues and be able to ascertain and explain and document that process really thoroughly. So, I remember one of our agents comes to mind where, the amount of copious notes he would make in a file on every single process, with the client, was so monumental, right? And at the end of the day, when the file was completed, like, he had notes and notes on everything. And that's where it really makes a big difference when you go to court and you're able to really substantiate and document and prove to the judge that you went above and beyond to make sure that your client understood the document and understood the process.
Yeah, and just to getting back to best practices, I mean, I think what you said was great about the way that your brokerage works. One of the key issues in that case we were just discussing, and relying on previous precedent cases as well, is that it may not actually be enough to give a blank VRA. It has all those provisions, but until it's filled out, until it's completed, until those actual dates are entered into the VRA, that's what the client really needs to understand. And so I think, just talking out loud, best practices entail going over those specific dates and not simply a blank VRA. And I'm seeing the whole case would have been, my clients would have had no defense had the agent done one thing, which is send a copy of the BRA to my clients or to the purchasers, basically as soon as it's signed, and say, as discussed, here's the BRA. There's, a few important provisions, the timeline, the holdover provision, the geographical location, and, the commission percentage. These are the things we discussed. Here's a copy for you. It's an important document. Highlight that it's important. And if you have any questions, please let me know. That one email, which, real estate agents could have a precedent email where they just fill in the client name, fill in the percentage, holdover date, etc., would defeat, I think, every single BRA enforcement defense ever. And so
Right.
really that's best practice, I think.
Right. And because if you do that, then it's incumbent upon the buyer, when he receives that, to say, no, like at that time, no, that's not what my understanding is. That's not what I thought I was signing. I don't agree to that. Not wait a month later when they buy another property, have another agent commission, and say, oh, I never really accepted that BRA. Well, you should have not accepted it when you first got it, or communicated something at that time, right? So I
Yeah,
think
that's
that's
absolutely
great
correct.
advice, Jake.
Yeah, that is great advice. And, we're always learning. So, filling in the dates and making sure that the BRA is complete is what, I got out of this. And, I will certainly be relaying that back to the agents for sure.
Yeah, and I
I'm not
think the
sure.
other big takeaway here is everything is relevant when you're going to go to court, like those time logs, any communication, whether it was by text, by email, phone conversations that you then confirm in a text or an email, like that's part of best practices. So you can have some evidence in court to say, not only did I present a properly completed BRA, but I actually explained it. And here's the evidence. Here's how I can back up what I'm telling a judge under oath, but I've got actual texts or emails or phone logs or something. And I think you did a great job to just looking at the timing. Like, right, it was a 4-minute call versus an 8-minute or 10. Like, that's a turning point in your case. It's brilliant.
Thank you.
Yeah, hard to argue against that too. Awesome, Jake. Well, listen, thanks again for joining us. Like, what a great episode. Lots of takeaways and lots of learning lessons. And We're going to have you back next time because we're going to jump into and peel back some of the layers on a case that you personally litigated and you very recently heard the news. So very, very anxious to jump into that with you in the next episode. Thank you so much for joining us, and we'll see everybody next time.
Looking forward to it. Thank you.